John Lewis Partnership PLC.
Yes, Ms Foster.
Thank you, my lord. May it please the court, I appear for the appellant claimant in this matter, together with my learned friend Miss Whitaker.
Yes.
She appeared at the trial. I appeared at the first appeal.
Yes.
My learned friend Miss Davies represents the respondent defendant, and she appeared on both occasions below.
Yes.
As you're obviously well aware, this is the second appeal from the order of Mrs Justice Ellenborgen, dated the 30th of September of last year.
Well, I can tell you, Ms Foster, that we have read both the trial judge's judgment and Mrs Justice Ellenborgen's judgment. Thank you. And we have, of course, read the skeleton arguments.
Yes, well, I'm very much obliged. I'm going to just take, hopefully, in as short a form as possible, a number of points. First of all, to look at the scope of the permission to appeal. Next, the issues in the action, followed by the undisputed facts, which of course form the bedrock of both judgments. And then an analysis as to why, in my submission, the findings below are not sustainable. And so, can I take it I don't need to take the court to the order of Lord Justice William Davies?
No, we've read that too.
Thank you very much. I was then just going, hopefully, to provide a helpful summary of the findings of both judges in a very succinct format in relation to the substantive issues. The first issue is in relation to the status of the defendant respondent. Was it an occupier? And the trial judge discussed the evidence relevant to that issue, paragraphs 21 to 32 of her judgment. She concluded at paragraph 33 that yes, the defendant respondent was an occupier, but its control was limited to dealing with immediate hazards, putting in place interim measures, and reporting any issues to the local authority. The context being that the local authority owned the car park. It was a public display, pay and display car park, but it was used predominantly by the respondent's customers, who would use it to go and shop at the supermarket. That was the trial judge's analysis. The appeal judge discussed the evidence, paragraphs 41 to 49 of her judgment. She agreed with the trial judge on the status of the defendant as an occupier. She answered that question in the affirmative, and also agreed with the trial judge that the occupation was for limited purposes only, but she added and expanded upon the purposes that she thought appropriate to include within that net, so to speak. And she, at paragraph 50, stated that the defendant would also have the ability to put up warning signs and to reiterate to the local authority any concerns that were not addressed within a reasonable period of time.
What right would Waitrose have had to put up signs in Hillingdon's car park?
Well, it had. There wasn't any evidence on that key issue, because, as the court knows, the defendant chose to call only one witness, the branch manager. And I will, I can do it now, make certain observations about that lacuna in the evidence, which by its absence simply led both judges to reach conclusions that, in my submission, defied common sense and weren't really justified on the evidence. Would it be helpful if I made those points?
Well, I think Miss Wood says in one of her witness statements that signage had to be agreed with Hillingdon, and it was their central property department which did that. So it didn't look as though there was an unrestricted ability on the part of Waitrose simply to put up signs in
Well,
Hillingdon's car park.
That may well have been the case, but this is a large commercial organisation paying £18,000 per annum for the benefit of having its own adverts put up in the car park and on the back of tickets. It's reimbursing customers who use the car park, who go into its store. It's undertaking a number of other activities in relation to the car park, and so simply to state that it didn't have the power to put up a sign is not the end of the matter in my submission, because the court should have gone on, rather than just accepting the store manager's evidence that was clearly only in relation to her power and authority, to actually ask the question, well, what if this large organisation had actually wanted to do something about the state of the bay or to put up a sign, etc. What in the real world, applying common sense, would it have done if the matter had been properly escalated to the people in the organisation who might have had some ability to address the point? Would it be helpful if I now, before I come on to the going back to my summary to the state of the premises, would it be helpful if I just make certain observations that in my submission are relevant to the defendant's power to make changes, which would,
Yes.
of course, answer your lordship's question on that issue? I've made the point that the defendant only chose to call one witness. She was Rebecca Wood, the store manager. It didn't call any senior employees who may have provided better insight into the defendant's relationship, contractual and otherwise, with the local authority, and so as to what might have been possible had somebody actually wanted, from a common sense perspective, to do something about the state of the car park. In her witness statement, reference paragraph 26, page 221 of the main bundle, Rebecca Wood stated that the defendant had no control and no financial interest in respect of the car park. Both of those assertions were factually inaccurate, but it was that approach that informed and coloured the manner in which the defendant defended the claim. Your lordship, the court is aware that the basis of the defendant's defence at trial was that it wasn't actually even an occupier of the car park. And from that submission, a number of other points were put associated with that point. The trial judge summarised those points, the grounds of the defence, paragraph 23 of her judgment in the bundle at page 147. Suffice to say, that was the defendant's starting point. The other point about Rebecca Wood's evidence is that it needs to be viewed through the prism that she hadn't actually identified the area, the bay that is, as a risk that needed any attention. So from her point of view, there was nothing that needed escalating. There was nothing to escalate. The transcript references that would assist your lordship and your ladyships on that point are in the bundle at 90 and 92, where, in short, although there had been previous accidents involving elderly persons who had parked in the disabled bay, tripping over the curb, prior to Mr. Judge, the appellant's accident, her view was that there hadn't been enough of them to justify any action being taken. And so the defendant's evidence, in my submission, needs to be viewed through that perspective. She also, obviously on behalf of the defendant, sought to distance the defendant from the car park on the basis that it didn't form any part of the land taken over by the defendant when it built the store. That's her first witness statement, paragraph 10, page 218. And that statement is immediately problematic because when I take the court to the photographs, which no doubt you already had a chance to look at, you will see that part of the building comprises a canopy which actually hovers over the disabled parking bays. And so the line between what is actually under and then perhaps arguably part of the appellant's remit and the car park itself is blurred in any event.
What, just because of the canopy?
Beg your pardon?
Just because of the canopy?
Well, my lady, not just because of the canopy, but the point I make is that Rebecca Wood was doing her best by means of invoking a number of what she no doubt considered to be valid legal arguments to distance her employer from any responsibility for the car park. And I make this reference simply to put into perspective her attitude, which was that this actually wasn't anything to do with the respondent. There'd only been a few accidents, so no one needed to be bothered about that. And actually, when we look more closely at, and I've just given two examples of points that she made, they're not compelling in all the circumstances.
Well, the judge didn't find them so because she found that Waitrose was an occupier.
I'm sorry, I can't hear your ladyship.
The judge found that Waitrose was an occupier,
Yes.
so you don't disagree with that?
Not at all, no. But I'm seeking to address the question raised by my lord in relation to what, if it had wanted to take any action, the respondent could have done. That's the point. I make all of these points in order to address.
Just to
that
cut to the chase,
question.
what do you say Waitrose should have done in order to comply with its duty?
Well, it should have done exactly what the learned trial judge concluded it should have done. It should have reported the matter to Hillingdon, and when nothing was, if and when the local authority hadn't responded, and we don't know because it never was reported, it should have been followed up, because as a matter of common sense, one can't be inviting elderly and disabled persons to park in a car park that one has some authority over, that one knows is hazardous. One cannot allow that state of affairs to continue without attempting to do something about it. And the fact here is that the respondent is, and of course the court can take judicial notice of the fact that it is a large, well-resourced organisation. If it had wanted to take action and sort out the state of the disabled parking bay, of course, as a matter of common sense, it could have done so. And
Sorry, just explain what you mean by it could have done so.
Well,
What is it that you say Waitrose, never mind what it could have done, what should it have done? Because we're concerned with a duty.
well, there were a range of solutions that in my submission were open to it, having identified a hazard, which of course it never did. It could have put the bay out of action by putting a cone in it.
Well, the trial judge was against you on that.
I beg your lordship's pardon.
I think the trial judge was against you on that. She said that that would have gone against Hillingdon if they had simply closed the bay, if
Well,
Waitrose
yes,
had closed the bay.
But there was no evidential basis other than Miss Wood's assertion that she couldn't do that to support that contention.
Well,
If
it
Miss-
wasn't there though, because this was a car park used by users other than the customers of Waitrose, and therefore they may have felt that Waitrose was acting above its responsibility or rights to close down a bay.
Well, lady, if Waitrose had been challenged by the local authority for closing down the bay, that would then, of course, have led to a proper discussion as to why they'd done that. No doubt Waitrose would have notified the local authority as to why they'd done it. And in the real world, no local authority is going to object with respect to a supermarket in this situation, bearing in mind the commercial relationship, taking a reasonable step in order to alleviate what was a hazard. And
But
so
there's a problem, isn't there? A procedural problem here. Your particulars of claim don't allege that Waitrose should have closed the bay. So it's not surprising that no evidence was given about it because it wasn't part of your case.
well, my lord, there are that point is not accepted. The case was framed, and we can go to the particulars of claim if we need
Yeah.
to, on a wide basis with the usual catch-all provisions. And in terms of evidence, the category of evidence I'm now seeking to address, the appellant made great efforts to secure disclosure from the respondent that failed, despite an order made by the court at an earlier stage in the proceedings. And the respondent's failure to make proper disclosure is dealt with comprehensively by the trial judge at paragraph 20 of her judgment, page 146 in the bundle. If I could take the court to that. It begins, I will now say a word about the defendant's disclosure. There's been piecemeal disclosure by the defendant in this case, necessitating an order for specific disclosure and then an unless order. As I have said, the defendant's sole witness is Miss Wood. In my judgment, she did her best and was honest and open with the court, but she does not seem to have been assisted to make the searches that she was required to do properly. Therefore, for example, it appears that she only searched her emails on the morning of the trial for emails containing her variant of the spelling of the word curb, C-U-R-B, a North American usage. There was also very limited material supplied from the defendant's central systems. Apparently some data has been lost due to a change in its IT systems. And it is simply said that they had no specific car park file because this is not their car park. There's no reference to any inspections of this car park by the maintenance operations manager referred to in the defendant's risk assessment, although Ms. Wood told me that there were people who occupied that post at the relevant time. So, my lord, back to the appellant's criticism that I was making earlier about the state of the evidence. The court only had before it evidence from Ms. Wood, who, of course, was limited in her ability to address the very important issues that, in my submission, the court needed to have the ability to address. And of course, the evidential burden could not have been upon the appellant to answer those questions. And just cutting to the chase, in short, the bay having been identified as giving rise to a risk, in other words, being hazardous, the respondent having been characterised as an occupier, in my submission, the evidential burden must then have shifted to the respondent in order to explain why the steps that it hadn't taken any steps, were reasonable in all the circumstances, such as to discharge its duty as occupier. And so what, by the logical extension of your lordship's observation is that the evidential burden is being shifted to the appellant, when actually it's not for the appellant to answer these questions. The appellant can't, it doesn't have access to that information. And so from a common sense point of view, this bay was hazardous. The party, the occupier with the most daily access and knowledge about its usage and the problems created by the hazard was the respondent. The respondent, in my submission, had to do something in order to sort out the problem, and it simply defies common sense to reach the conclusion that because Miss Wood herself purported retrospectively, of course, because at the time it wasn't even in her mind that something ought to be done, because she herself retrospectively purports not to have been able to do anything herself, that is not the end of the matter, because the question then arises, well, if you couldn't do anything, Miss Wood, you're the branch manager, there's obviously a line of authority in the respondent's organisation. Why didn't you escalate the matter to ensure that somebody who could have suggested a solution was appraised of the problem?
What was the problem?
Lady, the problem was the state of the premises, and specifically the state of the disabled bay.
Do you
In what
mean
respect?
state?
I'm sorry.
Sorry, no. Do you mean state or design? It was not defective. That was agreed. It is not appealed. Are you talking about design?
The trial judge perhaps answers that question very well, and it's a combination of a number of factors, which of course includes the design.
Can you just please identify exactly what you say is the hazard?
Well, the hazard is, as set out at paragraph 38 of the trial judge's judgment.
Yes, the danger comes from the space at the side of the car
Yes.
and the need for elderly and or disabled customers to manoeuvre between the side of the car and a
Yes.
curb. But that's not what the claimant was doing.
Well, my lord, he was trying to get back to his car.
He was
So-
in the adjacent bay, stepped or wanted to step up onto the curb, and his foot caught on the curb somehow or another, and he fell over.
My lord, yes, he did. And so, with respect, and of course that point is made by the appeal judge. And in my submission, that's splitting hairs because it doesn't acknowledge the reality of the situation. So the parking bay was unique in the line of parking bays. It was narrower than all the other bays. It didn't have the benefit of the yellow hatched markings at either side of the where the car would park, and it had curbs at each side bordering it. And I assume I don't need to specifically take you to the photographs now. I will if it would assist. And so the problem faced by the appellant was that, and bearing in mind that the whole point of a disabled parking bay is to provide level access, because it's known, of course, that those who are elderly, and the appellant had just had a hip replacement, those who are elderly and or disabled may have difficulties navigating and negotiating obstacles, including steps. And so the problem here was the curb, because having alighted from the vehicle, he wasn't able to walk down the side of it because there wasn't enough space.
Well, is that strictly correct? Because as I understand his wife's evidence and his wife drove right next to the curb because he would step out of the car onto the curb. So that was a decision made by his wife.
Well, my lady, she took up that position because there was a plant stand at the right-hand side. You've seen that in the photographs, and her evidence was that they were hanging over into the bay, And yes, it's correct. She actively chose to align the car away from the plant stand, nearer to the left-hand curb.
Well, forgive me, she aligned it in order to allow him to step out of the car straight onto the curb. Is that not correct?
That is correct, my lady. But she had to do that because that was the only, on her account, the only option, bearing in mind the configuration of the bay.
Could you just show us where either the trial judge makes that finding or there is some evidence about it?
I'll
Trial
have to-
judge says in paragraph 9, as Mrs Juge was not getting out, she parked over to the left of the bay in order, she said, the claimant could step onto the curb. Now, there's nothing there about planters.
There isn't in that paragraph, but as a matter of background, there was a planter. I'll have to just go to the transcript and hopefully find that.
Well, if you're saying that Mrs Juge had to park on the left because of the planters, then at least we need to see some evidence about that. There's no finding to that effect.
No, well, there isn't, my lord, but that again, with respect, isn't the whole story, because the point is, this was badged up as a disabled parking bay, so she was encouraged to park in there by reason of that advertisement, having and had done so before without any difficulties, although I submit that's entirely irrelevant. Having decided to park there was a plant stand on her right-hand side, and for whatever reason, we know that she parked, and I don't dispute the fact she parked nearer to the left-hand curb, because her thought process was that if she did that, her husband could then step out onto the curb.
Yes, nothing about planters.
Beg your pardon?
Nothing about planters.
Well, I'll come to the. In fact, let me go to the transcript now, because her evidence was. So page 30. Page 30 at starting at 16, but your wife parked more to the left. Yes, this is Mr. Judge's evidence. Yes, because on this side, on the right-hand side, there were some plants displayed, you know. And then it goes on line 24, but they were hanging on the side. And then let me go on to find the correct reference in relation to page 49 in relation
But
to...
the plants were on the wife's side.
They were, yes.
Yes. That's what Mr. Judge said. And the judgment records the evidence of Mr. Judge, which is that he was aware of the curb. So
Yes,
isn't that the point? It goes straight to it, doesn't it? The judge found as a fact that he was aware of the curb, but effectively he didn't lift his foot high enough.
That's correct, yes.
And that caused the accident. So if he was aware of the
Yes.
curb, even though it was a danger, you say, doesn't that go to the heart of causation? It was an accident.
well, milady, now obviously that's not accepted.
Well, the finding of fact isn't accepted.
He was aware of the curb, but he was an elderly man.
Yes, but do you accept the finding of fact made by the judge as to the mechanism of
Yes,
the...
indeed, and I hope that's evident from the skeleton submissions. I don't seek to overturn any finding of fact in relation to how this accident occurred or as to the characteristics of the parking bay.
If he was aware of the danger, as you would have it be, the curb, and he was picking his foot up to clear the obstacle, but didn't pick it up high enough, how does that give you the necessary link between the...
Well, milady, that's quite straightforward, because the whole point of a disabled parking bay is that you are making allowances to accommodate people who are disabled or elderly, and you therefore understand, hence the requirement for level access in these situations. You understand that although users are going to be aware of curbs, obviously he was aware of the curb, it was there to be seen. They are nonetheless going to be doing their best to navigate such obstacles, and doing the best that they can. It is not always going to result in a happy ending, because old people tend not to have the same ability as healthy young people to negotiate such obstacles.
But why do you say that disabled access requires a level access point?
Well, milady, there isn't any expert evidence before the court. An application was made for such a report in the earlier stage and turned down.
But this factual scenario that's played out in the witness statement, the evidence of Mr. and Mrs. Judge, was that it actually benefited Mr. Judge to step down to the curb, which is why his wife parked in order to enable him to do so.
Well, because there wasn't enough space for him to step out in the space that was left, bearing in mind the position she'd taken up to park.
Well, that's not what she says, is it?
Well, milady, that's in my
something
submission
that
is
you're extrapolating from the evidence.
I can take you to what she did say. Page 49.
Thank you.
49.
Page 49 in the core bundle, my lord. So, line 13, this is the evidence of Mrs. Moan Judge. Examination in chief starting at page 46 and cross-examination starting at page 47. And then on page 49 at line 13, there was no room on this side because on that side they put the plants. And I wasn't going to get out of the car because we were just going to pick up the rolls and he was going to be in and out. And then line 19, to be on the safe side because there are plants there, so you can't just put next to plant, there's not plants, there's not much room there.
I think we have to start further up the page, don't we? Because the question was, but on this particular day, you had a choice to park wherever you would like, and you didn't have to. You said you parked far over to the left. You didn't need to reposition your car in order for your husband to get out safely. And what she said is there was no room on this side rather than there was no room on his side. So that the use of the bay, the width of the bay, was determined, Mrs. Judge said, because she wasn't going to get out, so she parked so that her side was next to the plants.
And if you go on to the next page, page 50, line 14, more evidence suggests you very purposely parked to the left to allow for plants, and knowing that will be only foliage, it's your evidence today you parked to the left for the convenience of your husband. That's right. And if you had wanted to get out of the car, you would have had lots of space. Yes, I would have. Think so, but I did not.
Yeah, well, my lord, that is the evidence.
Yeah.
And it doesn't alter my submission that Mr. and Mrs. Judge were persuaded to park in a disabled parking bay, and by doing so were presented with a situation that objectively caused issues. And the fact that she may have parked further to the left because she thought that might be more convenient for her husband arose from the layout and the configuration of that bay. If there hadn't been a curb there, she wouldn't have had to undertake that thought process. but there was. So her actions were dictated by the situation she found herself in that bay.
Have you appealed the judge's finding that Waitrose were not responsible for the design and layout of the car park?
No, well, they weren't. So that's
So the configuration of the bay we see on the photographs, it's not something that's been temporarily marked up by Waitrose for their own convenience of getting more disabled customers in the store. This particular bay that we're talking about has got a very clear delineation by a concrete surround, hasn't it, all the way around?
it has, yes, yes.
And the width itself, it can be used by the person who's going to park there in whichever way they feel best. And as my lord says on page 29 of the transcript, page 50 of the bundle,
Yes.
line 2, and it was convenient for your husband to step out onto the curb. That's right.
Well, my lady, yes, but only because that's where they were parked, and that was the best, that was convenient in that situation. The evidence isn't that she deliberately parked in that bay because she wanted a curb for her husband to step out onto. It was, they parked in that bay, and she described the plants, etc., and how she parked, and in that context, it was convenient for Mr. Judge to step out onto the curb. And that, in my submission, is...
You've talked about design of disabled space and there should be room to manoeuvre and so forth, but Mr. Judge wasn't in the disabled space, he was in the next door space.
Well, my lord, that again, in my submission, is not a fair interpretation of the situation. So there was no room for him to walk down the side of his car. That is evident. So in order...
But that's because of the way his wife chose to park.
Yes, my lady, but his wife parked as she did. I've already gone over that point. I don't want to be repetitive. They were in a disabled parking space where he was not able to walk down the side of the car to get back to his car. And it must have been in the contemplation, as the judge, quite rightly, I submit, found in paragraph 38 of her judgment, that the combination of all of those circumstances gave rise to a hazard. And the fact that when he tripped, he wasn't trying to squeeze himself down the left-hand side, the fact that he was actually having to step over the curb and in order to get back into his car. Her finding was that he caught his foot on the face of the curb as he was trying to get to the passenger car door. So yes, he was approaching his car door from the bay next door. And the appellant's case, and my submission, is that he had to do that because of the configuration of the bay. And of course, we have other accidents that show others face similar difficulties when using that particular bay.
Well, we've got other evidence that there's been trips and slips, but we don't know the circumstances of them.
Well, my lady, we do in relation fairly fully in relation to at least two. But would it be more helpful if I just I've identified to the court the trial judge's finding of fact that the bay constituted, she called it, an unreasonable danger.
Yes.
And would it be helpful if I just gave the court the references, the comparable references in relation to the appeal judge's findings, because she discussed this issue at paragraphs 53 to 54. She considered the trial judge's analysis, concluded that actually there wasn't a problem because, and a number of points, I'll summarise them. The danger was obvious. She undertook her own analysis of the photographs, and that, in her mind, confirmed that proposition. The claimant, she said, had used the bay before without any mishap. She found that to be a relevant factor, as had thousands of others also using the same disabled parking bay. And finally, if a disabled elderly person didn't think the bay was suitable, she concluded that they had other choices. And the appellant's first submission in relation to those findings is that it wasn't open to her to overturn the trial judge's finding of fact at paragraph 38.
Yeah.
And the trial judge had heard the evidence extensively in the context of in the leisurely context of the first instance trial. She had the benefit of hearing from the appellant, his wife, and Miss Wood, and Miss Wood's evidence is fairly lengthy, and on the basis of her synthesis of all of Miss Wood's points, all the matters she brought into the evidence, the trial judge came to the conclusion at paragraph 38 that the configuration constituted an unreasonable danger in her words, and the appeal judge properly directed herself at.
Well, you say that, so although she set out the approach she should take at paragraph 40, when she got to paragraph 54, she didn't identify
Yes.
an identifiable flaw in the judge's reasoning, a gap in logic, lack of consistency, or all the other things that she said were necessary.
Yes, so
she
ignored,
just disagreed.
she ignored her own advice and substituted her own view, which the appellant contends is not permissible, and so she should, if it's submitted, have accepted and upheld that finding, and then her adjudication should have followed on from that that base factual finding. In relation to the points, if we're wrong about that, in relation to the other bullet points that I've identified, the appellant doesn't accept that any of them are justified on the evidence or as a matter of law, and the first point, the danger was obvious. Well, the curb was obvious, but the whole point of a disabled parking bay, advertised as such, is to minimise and to attempt to alleviate obstacles and any dangers that are known to make access and egress for elderly and disabled persons more difficult. And so the fact that the curb was visible is not, in my submission, to be conflated with the proposition that the danger was obvious.
But what I just want to understand what it is you say somebody should have done about this bay, never mind who it is for the moment. You're saying the curb should not have been there at all, or that the bay should have been wider?
Well, Lord,
You are saying.
it's really not complicated with respect. As a matter of common sense, you own a superstore. You have a lot of people inspecting the car park. You're recording accidents in this bay. You therefore know it's a problem. What do you do about it? You don't just say, oh, we can report it to the local authority, but if they don't do anything, that's too bad. We have to let the situation continue. Somebody who has some authority gets hold of the problem and sorts it out. It cannot be tenable or permissible for a situation that has been characterised as an unreasonable danger to be permitted to persist. And whether that solution lies in simply, as we now understand that bay is used for plants and not as a parking bay, that's obviously, I can't give evidence. But whether one cones it off, persuades a local authority that it shouldn't be used at all, whether one makes some structural alteration, there are a range of possibilities that somebody looking intelligently at the issue could have come up with. But we don't have, there's a lacuna in the defendant's evidence, because the defendant's evidence stops short at a branch manager who obviously didn't have much authority at all, saying, oh, well, I couldn't paint the curb or I couldn't do anything. And that's the end of the matter.
Well, forgive me, it's not that was accepted by the judge. It was open to you, had you so chosen, to have called witnesses from Hillingdon. The judge accepted that given the parameters of Waitrose's responsibility, they were not responsible for painting it.
Well, my lord,
It seems to be accepted that they played no part whatsoever in the design or structure and were not responsible for the design or the structure.
Lady, I don't suggest that Miss Wood should have, or anybody else should have painted the curb necessarily. But the judge did find that Waitrose should have reported the matter to the local authority, and the appeal judge did find that she went beyond the trial judge's characterisation of the ambit of the control, because she found that that Waitrose did have the ability and should, if they had identified a problem, that they should have badgered, she didn't use that word, but they should have followed up with the local authority had it not responded within a reasonable period.
Sorry, which judge found that? Mrs Justice Ellenborgen or the trial
Yes,
judge?
the appeal judge, paragraph 50.
Paragraph 50.
50, Mrs Justice Ellenborgen, paragraph 50 of her judgment.
To reiterating with reasonable frequency.
Yes, so the end of that paragraph.
Yeah.
On the evidence, that control had extended to the ability to put up warning signs where necessary and to reiterating with reasonable frequency any concerns regarding issues which had not been attended to by LBH within a reasonable period.
Now that was also overturning the trial judge's finding of fact, wasn't it?
Yeah, she's talking hypothetically here because she, having found that nothing needed to be done, this obviously wasn't relevant in the final analysis, but in her generic assessment of the ambit of the duty, this is how she put it.
But what failure of logic, lack of consistency, etc., does she identify in the trial judge's finding to enable her to reach the conclusion she did in paragraph 50? I mean, you've argued very persuasively that on the question of whether the problem was obvious, she shouldn't have interfered with the trial judge's finding, but yet at paragraph 50 she does.
She does, yeah. She expands the. In interfering with it, she enhances it. Can I put it like that? On that
Well,
point.
yes, but
She doesn't undermine it as much as enhance it.
But on what basis? She
Well,
just
on her
disagrees.
own, adopting a jury point approach and making her own common sense analysis.
But there's a little bit of inconsistency. On the one hand, you say she shouldn't have adopted a jury approach in deciding whether or not the danger was obvious. On the other hand, you say she should have done
Yes.
in deciding on the scope of the duty. They can't both be right.
Well, Lord, I
can they?
don't say she should have done. I point out this is what she has done. This is what the appeal judge did do, and in relation to the trial judge limiting the ambit of the duty to reporting to the local authority, the trial judge didn't go on to say, and having reported the matter, you must then follow up if they don't do anything. She found that actually they were pretty useless and wouldn't have done anything anyway, so that was the end of the matter. But I submit that the trial judge's final analysis that led to the claim being dismissed, because all the way through she's found in favour of the appellant on the substantive issues, but then at the end she departs from the appellant's point of view by her conclusion that the local authority wouldn't have done anything, so therefore there's no causation. But I submit that wasn't a logical or justified conclusion, because to say that you can get away with having noticed a hazard, having reported it, and knowing that it's something that needs to be attended to, you can get away with not attending to it because somebody else who might be able to assist you in that respect it isn't going to do anything about it. And that's where we come back to the lacuna in the evidence, which, and to return to my Lady Justice Davies's point as to why didn't the claimant call any evidence on that point. The claimant, it wasn't open to the claimant to summons Waitrose witnesses in order to get to the bottom of who might have addressed this issue.
You could have called somebody from Hillingdon. to
I
say-
beg your pardon?
You could have called somebody from Hillingdon, couldn't you, to say, well, if only Waitrose had told us about this, we'd have done something about it.
That was my point. It
Well-
was open to you. There's no property in a witness. It was open to you to call
No.
anyone from Hillingdon, subpoena them if needs be.
My lady, that's in an ideal world, of course, we'd all call many witnesses who we can't usually otherwise get our hands on for various practical purposes, but that didn't happen here. But I go back to my point about where the evidential burden lies. It doesn't lie with the appellant, because he simply needs to establish occupation, that there is a hazard, and the fact that it would have been pretty straightforward in my submission for something to be done, even as an interim measure, pending, as Waitrose did in other circumstances, pending resolution, squares the circle and makes out his case. And the matter stopping short at Miss Wood, who purportedly couldn't do anything, and no further interrogation being applied or evidence called by the respondent to address that lacuna, in my submission, doesn't justify both of the judge's conclusions, as we see.
Wherever the evidential burden lies, do you accept the legal burden was on your client to establish breach of duty and causation?
Of course, yes. Can I go back to the bullet points that I'd put forward, that I'd identified arising from Mrs Justice Ellenborgen's analysis at paragraphs 53 and 54 of her judgment. The first being the danger was obvious, which I've dealt with. The second, as confirmed by her own analysis of the photographs. And then the third point, the claimant had used the bay before, and the fourth point, as had thousands of others. In my submission, that is a red herring, and the fact that others may have used the bay, most of them come out of it unscathed, does not mean that it wasn't hazardous, does not undermine the trial judge's analysis of paragraph 38, and cannot excuse the lack of action on the part of Waitrose to do something about it. And I have referred the court to the case of Brioland Limited and Searson 2005 EWCA Civ 55 and the judgment of Lord Justice Buxton,
Yes.
which you're all obviously very aware of, and I assume it won't be helpful for me to read out the relevant paragraph.
Not necessary. Let me just go back to what you just said. You said does not excuse the lack of action on the part of Waitrose, and I quote your words, to do something about it. Now, what?
Yes. To address the hazard.
Yeah, I know. What?
Put a cone out, talk to the local authority, redesignate the parking bay as,
So let me just take this slowly. Put a cone out, so that's blocking off the bay.
block it off, put it out of use, take away its disabled status, so you're not encouraging disabled or elderly people to park there, so it's just a normal parking bay. Use it for something else. Any of those permutations would have been satisfactory.
Right.
The
And was any of this advanced in the pleading?
As far as I'm aware, yes. Shall we go to the
Yes.
page?
Page 193 is what you
Yeah,
say.
192. Thank you very much. So the specific allegations of negligence start at page 193, paragraph 3. So a general averment at number 1, failed to remove the curbed area, failed to provide step-free and or level access, failed to have regard to certain standards that ultimately the court would not consider, didn't consider.
But there's nothing that goes close to the three things that you mentioned, my lord. That is, block off the bay, take away the disabled status, or use it for something else.
Well, providing level access would have been tantamount to that measure being taken. And if a technical pleading point is to be taken, I'm not sure it was taken below. But
Well, it's not so much a technical pleading point. You are criticising quite heavily Waitrose for not calling evidence about particular points.
Yes.
Now, a party to proceedings prepares the evidence it's going to call by reference to the case which is alleged against it. So if you haven't alleged that Waitrose should have put out a cone, taken away the disabled designation or use it for something else, it's not surprising that there's no evidence about it.
well, my lord, I beg to disagree with respect. It's quite clear that this pleading is graphically criticising the fact that this disabled bay did not provide level access. That is the theme and the thrust of the pleading, that there was a curbed area there, etc. And standards are referred to, so certainly when the case was initiated, the defendant had full notice of those factors. There was no level access.
But I'm sorry, I don't understand how blocking off the bay would have provided a step-free access from the
Well,
disabled parking.
All the other bays had level access, so he wouldn't have used it. He would have gone to another disabled bay that had level access.
The reality of this pleading is that it is directed to the design and specification of this bay, which now even you accept was not Waitrose's responsibility.
Well, my lady, I don't just accept that now. That's always been accepted.
Well, that being the case, this is the pleading which took you into a trial, and it might be said it was directed at the wrong defendant.
Well, my lady, that's not accepted either, but that's another point that I'm not able to. Is your ladyship suggesting that the local authority should have been sued?
No, I'm not making any suggestion at all. What I'm saying is these are allegations which are directed to a duty or a responsibility which, as a matter of fact, Waitrose didn't have. They were not responsible for the design and specification of this bay.
No, but my lady, if knowing that people are tripping over in their car park in this bay, and if one accepts that they then ought to have done something about it, one then has to ask what should they have done about it. And all the points that I've raised, all the solutions I've suggested now were put to Miss Wood in evidence below. And her answer was that the defendant couldn't do that. Not that, we don't have anyone here who can answer that question.
Why wasn't the
we
trial
need some
judge?
time to answer it,
why
but
was-
we can't do it. That was her answer.
Well, that was her answer. Why wasn't the trial judge entitled to accept that answer?
Well, because the trial judge, in my submission, ought to have evaluated that evidence in its proper context. And the context was that the branch manager might not be able to do that. She might not have had sway with the local authority. But somebody in Waitrose, her line manager, somebody in a different department, must have the capacity to sort out issues with disabled parking.
Or was
bays.
that put to Miss Wood? That she should have escalated it up the chain?
I don't think it was put specifically
No.
in those terms.
So
Her answer was quite adamant.
what is the criticism that you make of the trial judge in terms of overturning findings of fact, which we've seen that the appeal judge directed herself about? What is it about her acceptance of Miss Wood's evidence that you say cannot be rationally supported?
Well, in terms of the trial judge's analysis, the point where all of her findings are satisfactory and not contested until we get to the point what would have constituted reasonable care. So in other words, what should the supermarket have done? What should Waitrose have done? And
That's paragraph 40.
paragraph 40
Yeah.
and 41, her answer was they should have reported the danger to the local authority. We know they didn't, so good, so far so good. Where the appellant takes issue with her conclusion is that she went on to find that the local authority wouldn't have done anything about it, so therefore causation isn't established. I submit that actually causation doesn't come into the equation at this point in the analysis. All that needs to be addressed here is what should the supermarket have done, bearing in mind all the factors that we know the trial judge found. Answer, as per the trial judge's paragraph 40 to 41, it should have reported the danger to the local authority, and and it didn't. So that I submit is the end of the analysis. The judge then went on, as I won't be repetitive, to say, well, actually, they wouldn't have done anything anyway, so no causation. And the basis for her conclusion that they wouldn't have done anything was the fact that a couple of years later, they'd been dilatory in responding to a request to repair potholes.
Well, no, that's not fair, is it, Miss Foster? Because in paragraph 41, she says, I note that in response to the letter of claim, Hillingdon denied that the curb was defective or dangerous, and there's no evidence that it would have taken a different stance if the defendant had reported the accidents in 2012 and 2014. So it's more than just potholes. This is directed to the fact that the defendant had reported the accidents in 2012, 2014, which you say mirror Mr. Judge's accident, and that they had just denied that it was defective or dangerous.
Well, in relation to the letter of claim point, I did address that point with the appeal judge, and the obvious point there is that when a defendant...
No, I think you're going off beam, if you don't mind me saying so. The point was, I responded to you saying that the only evidence before the judge was about the response of the local authority to do with potholes. And I'm pointing out that in paragraph 41, that there was more than the evidence of the potholes. She says, I note that in response to the letter of claim, which refers to Mr. Judge's accident, that they denied that the curb was defective or dangerous, and therefore, implicitly, she drew the conclusion that if that was their attitude then, that provided some evidence to show what their attitude would be to the reporting by Waitrose in 2017.
And they ignored Waitrose's request to paint the curbs.
Yeah, well, thank you, my lady, for pointing out that matter, but it's a very different matter when a potential defendant receives a letter of claim and denies liability to...
Well, go back to the previous sentence. The evidence shows Hillingdon ignored the defendant's two subsequent requests to paint the curbs. And in my judgment, it's unlikely an earlier request would have produced a different result. That's her inferential finding. She says, well, Waitrose did ask them to paint the curbs. Hillingdon didn't do anything about it. Why should it have been different if they reported this any earlier?
Well, because the request to paint the curbs was in a different context. A report earlier followed up would have been in the context of elderly people falling over and sustaining injury. And one has to assume that faced with such a serious situation, the local authority would have been persuaded to take appropriate action.
Why should we assume that?
Well, my lord, because it would be reasonable to assume that organisations don't act in a way that would enable a dangerous situation to be perpetuated. And it comes back again to the lacuna in the evidence. Why wouldn't they take notice if they're told that actually we've now had, by that time, there were 4 or so definite, specific, very serious accidents that had occurred? Why wouldn't they take appropriate action?
Because they
Why
didn't
would
think
they?
the
Why
curb
wouldn't
was
they?
defective.
I'm sorry,
Because they did not think that the curb was defective, so that they were saying, we disagree with you.
well, milady, the curb wasn't defective per se, but if they'd simply been told
Or
the curb
dangerous,
is...
it says. Was not defective or dangerous. That's what the local authority was saying in response to a letter of claim, which was after the event, I accept. But why should we assume that the attitude they took then would be any different to the attitude that they took to the Waitrose complaints?
Well, my lady, for this reason, because we have to assume, I respectfully submit, that the description of the problem would have been as per the trial judge's description. And they would have had a proper full description of the nature of the problem. And having had a proper full description, would have acted appropriately, would have acted diligently and appropriately, not negligently. And so the upshot here is that the Waitrose's defence is premised on the illogical premise that because somebody else is likely to have acted negligently and not done anything about this situation, we are therefore exonerated, and that in my submission is illogical and doesn't reflect reality and how one might expect a problem to be dealt with in the ordinary course of business by 2 responsible organisations, and one has to assume that they are both responsible organisations.
Well, the very fact that you're bringing an action against them in negligence rather assumes that they're not responsible organisations. You can't make that assumption, can you? Because otherwise you're in a stalemate position.
Well, my lady, if they're not responsible, then that must favour the appellant.
In what way?
It comes back in full circle, with respect.
Sorry, I just don't follow that last submission. But if neither of them are responsible, that favours the appellant. How
Well, it must
can it
do.
do so?
They're not responsible because because they didn't report what was a hazard as identified by the trial judge initially. They didn't report it, so they are not, by definition, they are not responsible.
Well, they made a report in 2016.
Yes, but not a report that contained all the information that, if properly reported before the appellant's accident, would have been before the local authority. That is my submission on that issue.
Yeah.
The local authority would have to know what the nature of the problem was in order to address it. And if it was only told half the story or provided with information that didn't provide the full picture, then of course that might be a different outcome. But one has to assume that if the trial judge is correct, that the local authority would have been provided with sufficient information upon which basis to understand the nature of the problem as identified by the trial judge at paragraph 38. And it's on that premise that I submit it's inconceivable that two responsible organisations would not have worked out a solution to the issue.
Yeah.
Lord, I was dealing with the appeal judge's analysis and the bullet points that I'd identified, and then the final point that she made, paragraphs 53, 54.
Sorry, which
disabled
paragraph?
Elderly person.
Which paragraph?
I'm sorry, I'm going back to Mrs Justice Ellenborgen's
Yes.
judgment, 53, 54. I've summarised her analysis. The final plank is if a disabled elderly person didn't think it was suitable, there were other choices. In other words, other bays for them to go into. And I submit that that's really contrary to the whole purpose of a bay being advertised as being suitable for a disabled person, and that such a person should be able to trust the pointer without having to undertake some complex evaluation before they decide to park, in this case in the particular bay.
But didn't the trial judge find, as a fact, that Waitrose could not effectively challenge the determination of the owner and occupier of this car park, the local authority, as to what was and was not suitable to be a disabled bay? So when you keep saying that there was an invitation for those who were disabled to use the bay, the invitation by reason of the painting of the disabled sign that we've seen on the photographs, that was not something that Waitrose could do anything about, according to the trial judge's finding of fact.
Well, I probably covered the point because it goes back to what Miss Wood, the branch manager, was authorised to do or not, and to the point that even that being the case, that may well be the basis of the relationship.
But it's the finding of fact that's more important than the evidence, because it's the judge's determination on the facts. And she found as a fact that, for example, Waitrose couldn't put a sign up that differed in opinion to the opinion of the local authority who owned the car park.
Well, my lady, that may well be the starting point, that they wouldn't do that. But there must be circumstances where what might be the ordinary rules of the relationship might need to be renegotiated or reviewed.
Yes, you made that point.
Where something crops up that needs to be addressed.
You're saying that Waitrose were inviting people to use the bay for disabled parking.
My lady, yes, they were. Because they paid the local authority £18,000 per annum to put their signage up in the car park.
No, I think they paid the 18,000 for advertising on the back of the parking tickets.
They did, yes.
That's
yes.
not the same as putting signage up in the car park.
Well,
And that is indiscriminate between those who are disabled and those who are able-bodied. Anybody who'd got a ticket from Hillingdon would have had a Waitrose ad on the back of it.
they had their own signage in the car park.
They did.
Lord. And they had...
They did indeed, and Miss Wood gave some evidence about that. She said it was agreed between the Central Property Department and Hillingdon. That's what she says on page 220, paragraph 21.
Yes.
Our Central Property Department would have agreed with the borough at the time the branch opened as to what signage we could have in place. So that wasn't something that they were entitled to do. They had to agree it with the borough.
They did, yes. But this was a car park predominantly used by Waitrose customers. I won't repeat the point about the payments made and the signage. The disabled parking bays could be used by any member of the public, that is absolutely right. But for Waitrose or for it to be suggested that Waitrose were not inviting customers to use the parking bays would, in my submission, be inaccurate, because they were, in the sense that the bays were located right next to the entrance to the store. It was their store, they built it, obviously in conjunction with some arrangement with a local authority. We never found out what that specific terms of that were. But the suggestion that these bays are somehow isolated from and nothing to do with Waitrose, in my submission, is not tenable.
I didn't mean to suggest that, so I'm sorry if I've been clumsy in what I said to you. You were saying that they invited disabled drivers to use the bay by virtue of the signage.
Yes.
Yes. The point I was making is that Waitrose were not responsible for the painting of the car park, were they, with the signage of the disabled badge in order to drive into the bay?
No, in the sense that they, it would appear that they hadn't affixed the signage, that signage, no.
Or painted the car park?
Or painted the car park, no. But my point in response to that would be, but of course they were benefiting from disabled customers using the bays, and so to that extent, by having a supermarket right next to them, they were encouraging disabled persons shoppers to park in those bays. My lord, shall I just move on to my next
Yes.
point? Thank you. In relation to the analysis of the judgments, I've covered in relation to what would have constituted reasonable care. I've dealt with the trial judge's analysis, paragraphs 40 and 41 of her judgment. The appeal judge, paragraph 55 is the relevant point. In effect,
She never got that. The appeal judge never got that far because of her finding that this was all obvious.
Indeed.
And
yes.
you criticised that finding
Yes.
because you say that she wasn't entitled to reverse the trial judge on that finding of fact.
Indeed.
And if she wasn't, then she hasn't considered causation and all the rest of it.
Yes. And then we have what I might characterise as a sub-point, causation of the accident itself. And paragraph 19 of her judgment, the trial judge found as a fact that the claimant tripped on the face of the curb. That arises from earlier discussion at paragraph 12 of the judgment.
Yeah, and this is what he demonstrated with a pen and a white book.
He did. And if I can just take the court to the end of paragraph 19, page 146 in the bundle, it's the last three lines.
Paragraph 19
It's paragraph 19, my lord, is
of the trial judge.
Trial judge, page 146 in the
Yes.
bundle. In my judgment, it is more likely that it was a trip than a sudden collapse. I'm satisfied on the balance of probabilities that Mr. Judge has a real memory of tripping, and I find he did trip by catching his foot on the face of the curb as he demonstrated.
Yeah.
And
What that amplifies is what the judge has already said in paragraph 9. He got out onto the curb, stepped down onto the empty neighbouring bay, went round the back of the car into the store, came back with shopping bags, which he placed in the boot, walked round the back of the car into the neighbouring bay. When he got level with the front passenger, he went to step onto the curb to reach the door handle. He caught his foot on the curb and fell. That's the judge's finding.
Yes. And that follows from that analysis. And then in relation to how the appeal judge dealt with, if I can call it, the causation of the accident issue, paragraph 58, he misjudged his step. The danger was not causative. And I'm conscious that I've already canvassed that issue, and I don't know if further repetition is necessary. But in short, the point is that the reason he found himself in the position he was in is because the curb, the step, however we characterise it, constituted the sort of obstacle that anyone looking at a disabled parking bay would understand was likely to potentially give rise to issues with elderly and disabled people having to navigate it. And so that conclusion is not accepted, and the appellant contends that neither is it justified on the evidence. And he in the strict sense, yes, he did misjudge his step, and so it's not so much that terminology that is contested, it's the conclusion that by that method this was a pure accident and actually nothing to do with the danger created by the curb. And so the appellant's position is that he misjudged his step in circumstances that were eminently foreseeable, because that's what elderly people tend to do when they're having to step over things in a situation such as this. So the misjudgment cannot count against the appellant is how I put the matter. Yeah. Lord, in relation to the undisputed facts, I've covered most of the points in my earlier submissions, but just to ensure that I don't miss out anything that might be relevant, might I take the court, please, to a risk assessment at page 241. It's dated the 1st of July 2013. It demonstrates that the respondent undertook regular inspections of the car park with a view to identifying a number of potential problems. Obviously, it is a pro forma used by other Waitrose branches. The potential problems included within the remit of the inspection included any changes in floor surface or height, for example, curb clearly visible, and going over that's on page 242, about halfway down the second box, existing control measures and other likely factors. I don't suggest that this list fits neatly into the situation whereby one might be inspecting a disabled parking bay. It may to some extent, but I do point out, going into box 1 above under the heading hazard, the last part of that box. However, it is worth noting that for elderly customers, fractured hips are not uncommon, and according to NHS data, a significant number may lead to fatality. And so this risk assessment simply demonstrates that the defendant respondent had control over the car park, which obviously is not disputed.
Sorry, how does it demonstrate that?
Well, the Waitrose are taking it upon themselves to inspect the car park.
Yes, I mean what this says on page 241 is in branches where we, this was in the last paragraph, in branches where we do not own the car park, we ensure that any views about safety issues are promptly reported to those responsible for it. So that's
Yes.
their practice.
Yes.
And then if you go to page 242, third question under the existing control measures, is the surface of the pavement or car park in a satisfactory state of repair? And that's a box ticked yes. And then three further down, are any changes in floor surface or height, e.g. curb, clearly visible? Yes. And then towards the bottom of the page, other relevant local controls or conditions not listed above, and they say it's included. So that's the risk assessment. They
Yes, it is, my lord, and the list may or may not be exhaustive as far as the assessor is concerned, and it certainly doesn't contemplate undertaking any analysis of the integrity or suitability of disabled parking bays. But the points I identify specifically here are, your lordship's already gone to the point about safety issues being promptly reported, page 241, and the reference to elderly customers perhaps fracturing hips that may lead to fatality. And so the respondent has identified serious consequences that might potentially follow on from matters, from problems arising in their car parks that may need to be dealt with. So I just put that before the court as part of the factual background, because of course, having identified a hazard, part of the evaluation and analysis as to what might constitute a reasonable response, reasonable care, is to look at the potential consequence of not taking reasonable care. And here, the potential consequence with elderly and disabled people may, of course, be significant. The next factual evidence I put before the court is in relation to the evidence of risk and danger, and I just come now to the previous accidents identified by both judges, trial judge paragraphs 34 and 35, and the appeal judge at paragraph 54. May I just briefly take the court to, first of all, the first accident, 12th of December 2012, dealt with by the trial judge at paragraph 34. Other references in relation to where it's documented, supplementary bundle pages 28 and...
Sorry, where are you in the judgment?
Sorry, paragraph 34.
34. Yes.
Shall I paragraph 34, line 3, there is a summary of incidents and then some specific safety incident details. There is an incident on the 12th of December 2012 when a customer tripped over the curb, landing on his front, resulting in a cut above his right eye, a cut lip and a cut knee. The specific safety incident report puts the location as outside the branch exit by the disabled parking spaces. Witness stated the customer tripped over the curb. I think there is no more detail other than that. That, in my judgment, appears to refer to this bay. So that's the first accident that, and then I gave the court the document references. They are supplementary bundle pages 28 and 50. We probably don't need to look now, but that's...
Yeah, so there are 3 accidents before Mr. Judges.
3 accidents.
Yeah.
Would it be helpful if I took the court to the other accidents, or...?
If there's a particular point you want to make about them, by all means
Well,
do.
only that certainly the third accident on the 9th of August 2014 is very comparable to the appellant's accident. The second accident in 2013, the details are less specific, and so one might not necessarily take the view that that was directly comparable. And then we have a further accident after the appellant's accident on the 3rd of November 2015, dealt with in the trial judge's judgment at paragraph 36, page 150 in the bundle. After the claimant's own accident, there was another incident on the 3rd of November 2015, reading, elderly gentleman was getting out of his car when he tripped and fell over the curb, which runs along the long side the disabled parking bays. Injuries are not recorded on that one. Miss Wood said, when asked about whether this bay was in her view dangerous, that it was in fact the most popular bay used thousands of times by customers. She initially said there had been no previous accidents prior to the claimants, but then conceded when taken to the details by Miss Whittaker that there had been at least 2 previous incidents, but only 2, she said, in 2 years, which she did not consider a trend requiring her to report them. So that deals with that. And then the documentation in relation to the 2015 accident is at pages 29 and 46 in the supplementary bundle. My lord, that ought to deal with the undisputed facts, which I hope the court now has comprehensively. In relation to the law, I will, if necessary, but probably don't need to take the court at any great length to the relevant principles, unless it would assist the court for me to do so. I do need to notify the court that the latest edition of Clark and Lindsell was published at the end of September.
Yeah.
The 24th edition is now relevant. I haven't managed to do a complete word-for-word analysis of what might be different here. The paragraph numbers are different. What is of note, and I've flagged it up with post-its, is that this case at paragraph 1133 is now cited as authority for the proposition set out in under the heading obvious dangers and ordinary risks. It's cited as a proposition supporting the point that dangers which are entirely usual or obvious to a reasonable visitor may not give rise to a duty to act. And the reference here is to a raised curb in a car park may cause loss of footing.
Yeah, and that's a reference to Mrs Justice Ellenborgen's
It
judgment.
is.
Yes.
There's no further reference in the text to the context of the factual context, and then the footnote at paragraph 193 gives us that reference. If there are any other differences, I apologise in advance because I've not managed to identify anything that needs to be drawn to the court's attention. My lord, I do while skipping over what you know to be the principles in relation to occupier's liability, I do make reference to Clark and Lindsell in the 23rd edition, 1133, Authorities Bundle A11. The point that the point made, no duty is owed as occupier in respect of dangers which are entirely unusual or obvious to a reasonable visitor, is qualified on the basis that the exoneration of the occupier is premised on the avoidability of the danger. And that goes back to my submission that an elderly or disabled person, whilst being cognizant of the presence of a curb, might nonetheless not have the ability to avoid an adverse consequence because of their state of infirmity and such like. So I make reference to that point in that context. I also direct your attention to Clark and Lindsell 11.42, Authorities Bundle 19.
So 11, which?
11-42, chapter
42.
11, paragraph 42. Authorities Bundle, page 19. To make the point that the defendant must go further than to establish knowledge of a risk. It must show that the visitor was volunt, in other words, must be taken to have agreed to bear that risk. And so that goes back to the point of the judges choosing to park in the relevant bay and specifically positioning the car for Mr. Judge to step out onto the curb. And
Yes, and I would have thought something doesn't stop being dangerous just because you don't need to use it, if it is dangerous. I mean, if I put a bridge made of rotten wood over a stream, but there happens to be another one close by and you stand on the rotten one, it doesn't stop being dangerous just because you didn't have to cross the river that way.
no, but the point made by the appeal judge is that
No, I'm accepting your point.
yes,
Accepting
thank you
your
very
point.
much. Yes, I'm just, if the court would give me one moment to see if I need to make any further references. Yes, may I just make a brief reference to the case of Tomlinson and Congleton, cited by the appeal judge at paragraph 55, page 189 of her judgment. And she made reference to the judgment of Lord Hobhouse at paragraph 80 in that
Yes.
case. Authorities Bundle, page 118. In my submission, Lord Hobhouse was referring to the point that the response to a risk should be commensurate with the degree of risk. And earlier in judgment, Lord Hoffman, at paragraph 34, made what are familiar observations to the effect that one has to look at the likelihood of injury, the social value of the activity involved, and the cost of precautions that might need to be taken to eliminate any risk.
Yeah.
And in the context of the present case, I submit that the likelihood of injury here was high enough for something to need to be done about it. The social value point, obviously in the Tomlinson and Congleton case, that was a risky activity per se that the claimant was engaged in. Social value here, translating that point to the present case, would be in relation to the utility and the benefit of having disabled parking spaces for the benefit of the community and disabled and elderly persons, and in relation to the cost of precautions in order to do something about it, and undertaking a balancing exercise whilst synthesising all of the points that need to be taken into account. Couldn't be any cost basis upon which to argue against the risk identified by the trial judge being eliminated. And I've covered at length the response to the court's questions on that point already.
Yeah.
My lord, I think that probably covers all the points I need to address the court upon, unless I can assist any further.
I'd just like to ask you one or two questions about Wheat and Lacon, and particularly the speech of Lord Denning, which you cite as being the classic exposition of occupiers, who is an occupier and what the duties are. And I wonder if we could start, please, at page 46 in the authorities bundle, page 577 of the report. And we can see at the top of the page the basic facts. So the pub is owned by the brewery, Lacon. Mr. Richardson is the manager. He runs a public house. Mr. and Mrs. Richardson live on the first floor, and Mrs. Richardson takes in paying guests. And one of those paying guests fell down the back staircase because the handrail was too short and someone had taken the bulb out of the light at the top of the stairs. So that's the basic factual scenario. And Lord Denning talks about the meaning of occupier in the passage that you cite in your skeleton argument. Page 578, he says whenever D to F, whenever a person has a sufficient degree of control, he's an occupier, doesn't have to be exclusive, suffice it he has some degree of control, and then E to F, and whenever this happens, each is under a duty to use care towards persons coming lawfully onto the premises dependent on his degree of control. And then he gives some illustrations, and if you go on to page 580, bottom of the page 49 of our bundle, having decided that the brewery were occupiers, he said Mr. Richardson, who has a license to occupy, had also a considerable degree of control, so had Mrs. Richardson. All three of them were occupiers with a private portion. And then he goes on to address the question of the duty of care. And at the bottom of the D to E, he says the brewery were entitled to leave those day-to-day matters, that is, you'll see the lights are switched on, to Mr. and Mrs. Richardson. The circumstances of the case demanded that Mr. and Mrs. Richardson should take care of those matters in the private portion of the house, and of other matters too. If they had realised the handrail was dangerous, they should have reported it to the brewery company. Now that's exactly the duty that the trial judge found that Waitrose had. No more, no less than the duty that Mr. and Mrs. Richardson had. Not to do anything about it, but to report it to the people who could do something about it. Do you want to say anything about that?
Well, my lord, in the Wheat and Lacon case, my recollection is that ultimately the state of the handrail wasn't actually implicated in the causation of the accident, and so.
Well, I think the trial judge found that Mr. Wheat stepped out confidently from the third step from the floor because his hand came to the end of the handrail.
I don't think that was accepted by the appeal court. The appeal court found that a stranger had recently removed the bulb, and that had the light been on, the condition of the handrail would have been irrelevant. But I take your lordship's point that here the delineation of responsibility in the very specific circumstances of the arrangements at the public house was that the handrail was part of the structure of the premises, and in an ordinary landlord-tenant relationship, one would report that to the landlord if it needed sorting out. But actually the handrail here hadn't, in the Wheat and Lacon case, hadn't ever caused any issues and hadn't been deemed to be problematic by the tenants, by the other occupiers. And so But
No,
obviously,
I
if
follow
it
that.
had, it would have.
I'm just commenting on the scope of the duty that Lord Denning thinks that the Richardsons would have had they realised it was dangerous. It was a duty simply to report.
Well, well, in this context, but on these facts, but had the handrail been previously identified as dangerous, no doubt Lord Denning would have applied common sense and would have, as he was famous for doing, and would have come to the conclusion that actually, if a report had been made and nothing had been done about it, then the occupier ought to have done something to follow it up.
Yeah.
Is how I would address that issue. Lord, were there any other?
No, I have no other
No,
questions.
thank you.
No, thank you.
No, thank you very much. We'll just rise for a couple of minutes and see where we are. So don't leave the courtroom.
across the board, which is very stressful. I mean, it's probably stressful for them as well in a way. I just think judges need to be a bit kinder sometimes.
I find that some are better than okay, responsibilities is that okay?
Have you got kids?
Backhouse. My youngest has two, so I find that actually really tough.
For how long?
6 months with the first, 6 months with the second, and then 3 months with the third because he's in COVID. And I didn't want to be alone. So I got myself back to work all the weeks when I was there. And then I took a longer summer. So, and I've always done it full time.
That must be very taxing.
It's especially getting back on an even keel when you're back. So it's just I've been lucky that my practice is carried on because I'm nurse. I'm going to move this doing my case was passed on away and then they come back to me.
It's most of your work independent work.
At the time that my first landing it was about 70-80%. Say now, because I'm doing more of the extra stuff, that tends to come to some claimant-ish. So, yeah, I would say it's probably about 65.
My work is independent work. This is very rare. I've got claimant cases going on.
Mine tends to do the claimant work and demonstrate well. I've got a couple of RTAs and catastrophic injuries.
How's Decker Chambers working?
Miss Dobby, we needn't trouble you. We are going to dismiss this appeal for reasons to be given in writing later on. Thank you very much. If there are any issues about costs and so on, make submissions when you get the draft judgments. That will also be your opportunity to correct any English, but not to introduce new arguments or legal reasoning. Thank you.
What rise?
And that was an easy day for you.
I know. You do all the preparation, don't you? And then, because as you say, you never know where they're going to come from. So, I
No, how can you say? I've shown it you.
it is, yeah. It's you do.
Your
We've got
staff.
either, yeah. We've got Nicola's wonderful. She's wonderful. And I think we've got KTS as well.
Yeah.
You picked up 3 goodies.
So we're going to have you next.
Oh, I'm pretty part of the furniture at One Chancery Lane now, Decker, I'm afraid, but thank you for
No,
the suggestion.
I'm not going to take them off.
No, of course not. The suggestion, of course, that's all it
Okay.
was. But I mean, you're very upset.
Sorry?
You're upset with great people.
Yeah, but I think when
If women are sort of doing reasonably well at the bar, I think it's because no one ever encouraged me. I mean, I think it's really
I think that's absolutely right.
and Nicola is
brilliant.
She's a wonderful lawyer. Nicola's a real shame. We lost her at time of turbulence, I would say. But you know, she's a great acquisition for you. She's dedicated. She's hardworking. She's
she's
good
got
to have
2
around.
mentions as well.
Yeah, she does. She does. She had those when she came to you. And 2 persons.
Well, after she came to us.
Yeah. Mm. Yeah.
No, I know her very well.
She's,
Anyway, should we go? Excuse me, you're going to turn the live stream off?
Yes, sorry, I forgot.